Joining me now are the chair of the House committee dealing with these bills, Democratic Representative Zach Hudgens, and ranking Republican member, Representative Norma Smith. Thank you both for being here today.
Thank you for having us.
Yeah, thanks for having us.
First, let's talk about the Senate, the reincarnated version of the Senate privacy bill. There have been some changes since last year. Overall, what do you think are the strong points? And then we'll go to what you maybe see as potential weak points in the bill. Representative Hudgens.
Well, I really appreciate the work that was done over the interim with the Senate, with a bunch of stakeholders. The new bill is much easier to read. Consumers can look at it and see those rights really clearly enunciated. Things like your right to access data, your right to correct data, your right to delete data. It also clearly has obligations on those that deal with data, the folks collecting it and that sort of thing. So just as a reorganization, it makes it easier to read. I think that's important.
And Representative Smith, what's your initial take on what this bill would do and what it's meant to do?
So it's come back to us, or it's coming back to us in a bit of a different form. But I still have great concerns about this bill, and I think the fact that the AG has expressed concern, that all of the consumer advocates have expressed concern, ought to heighten all of our concern. This issue is something that we will live with for decades. If we get this wrong, it's vital that we get it right. And just a few of the areas of concern, yes, I think that I would agree with Representative Hudgens that there has been some improvement in some of the areas of the bill. But even as it came out of the committee in the Senate, there's still really serious concerns around the language about data minimization. I believe a company should be very careful in that they're only collecting that which is needed to process that which you expect of them. When you look at the facial recognition part is still a huge issue. When you look at the laundry list of exemptions and exceptions in the bill is so significant. One of the things that I think I'm particularly concerned about that is still in the bill, and consumer advocates have come and said, this is problematic. This is serious language as it relates to creating a loophole. And that's that even if you ask for your information to be deleted and company A says, okay, the language allows them to keep your information into perpetuity for internal research and product development and technology. And then I think most importantly, if you're going to grant rights, you have to grant access to justice. And this bill does not do that. It prevents an individual from being able to access justice if their rights are violated. So if you're going to grant rights, you have to grant access to justice. So those are the few of the things that I'm concerned about on the bill as it's coming out of the Senate.
I think we were referring to the private right of action and the fact that this legislation reserves the right of correction or punitive action with the Attorney General's office for an array of or patterns of abuse, I believe is the term. But we'll come back to that in a second. I do want to ask, what's your response to the argument that this could put some new protections in place where there are none, and that there could be a foundation that the legislature could build on over time? Is that a fair assessment or not?
I think it's fair. That's a lot of what the legislature does, is take a first step and then go from there. But that also assumes that the first step is a solid, good step, right? So we should, in this bill, grant rights to people and then make sure that there's some enforcement mechanism. If there's no enforcement mechanism, it's difficult to come back and fix things. If we open up a loophole that's too big, then it's going to be difficult to come back and close that loophole. So I think that it's a legitimate argument to say we should continue to work on these issues. We will. I think that privacy issues aren't going away. Data use is not going away. The big data economy is not going away. And it creates a lot of benefits to our communities and our society. But we need to make sure that we're not simply trying to get a good bill instead of a perfect bill. We're not fighting that out when in reality we have a bill that doesn't work. So we should really make sure that we're looking at the details and trying to do the best we can on this first shot.
May I just
Please.
add to that? I think it is important that we scrutinize this in a way that recognizes the testimony in both the Senate and the House. We had tech coming in and saying they don't that GDPR has its issues. They refer to it as the gold standard. That's Europe's standard for privacy. California, it's been rolled out. It's a $40 to $50 billion cost right now to industry down there. And yet there's this huge push here. And they've said they want this to be the model for the nation. They said it in both committees. And so we need to understand that what we're doing here could have impact not only for Washingtonians, but for every person in the United States. And that's why this model does become so important. It does become really crucial that the essential elements, no one gets what they want in everything in a bill. But when you have a corporate-centric bill being brought as a model for the nation, that ought to be of concern to everyone.
I mean, Consumer Reports and various other privacy advocacy groups, the ACLU, the Electronic Frontier Foundation, the EPIC, they've all put out statements. Last year they were not in favor of the bill. This year they say, you know, it's much better, but they do identify some loopholes that they hope to see addressed. But it's not the same sort of tenor, the tone of the objections isn't the same as before. It seems like maybe they think it's got a lot of good stuff in it. One of the loopholes has to do with the sort of the definition of sale or transfer, I believe, and sort of what a company can do. And
you know, I need to interrupt you because I think that's not clear on what they said. When you look at their bill, on their letter to us as legislators, for example, the Consumer Federation of America, which represents an enormous number of players, they listed 16 key issues as it impacts consumers. So to say that they still have just some concerns, I don't think really reflects. And some of those concerns are so significant, the right to access justice and the facial recognition and the data minimization. So I think it's important that we not underestimate. I think it's important to recognize that they're still red flagging this as having problems for consumers in a really significant way.
That is fair. That is fair. They did have a number of concerns, but at the same time, they did sort of celebrate the fact that there had been some progress made. The loopholes that you referenced too, specifically, some of the definitions of what we're talking about when we say data or consent come to mind, and particularly when you're looking at the opt-out provisions. Why not an opt-in provision is sort of that's one of the more significant objections that has been raised, because as anyone who's ever dealt with technology has probably experienced, privacy policies tend to be very long and hard to read, and sometimes some sites require you to go to multiple other sites to opt out, to choose not to have your data collected, and sometimes it's a highly confusing and very cumbersome process. So a universal opt-in might be a way that they could, I guess, avoid that, but at the same time, it seems that, is that too big of a hurdle for the tech companies to be on board?
Well, I can't speak for the tech companies.
Neither of us could say.
And I think that we deal with opt-in, opt-out on all kinds of legislation. You know, the parks pass, that when you get your driver's license renewed, you get to opt in or opt out of helping out the parks. With the data stuff, Europe really does have that opt-in model, and they have a huge administration to go regulate this stuff. I think trying to implement that in the US is a lot more difficult. Some of this is because the genie's out of the bottle, and recognizing that, having access to your data and then knowing how to correct it or delete it or object to how it's being used is kind of the next best thing. And that's the model that we've seen come out of California. That's this model. Let's enunciate these rights and then try and put some teeth into it. And that's our biggest concern, is about the enforcement process in this.
So we've got to pause there. We'll be back and have more discussion on these issues after the break. Welcome back. We're continuing our discussion with Representative Zach Hudgens and Representative Norma Smith. We're talking data privacy regulations and proposals on the table. So we were discussing opt-out clauses and the principle of why not give people an opt-in option. In other words, require people to give affirmative consent before their data is collected or to be used in specific ways. Now, let's look at, this is a response I got from Maureen Mahoney on behalf of Consumer Reports about, for privacy advocates, what's the potential worst case scenario, say 10 years from now, if data privacy regulations are not strengthened? And she says, quote, "We're concerned that if Washington state does not pass a strong law, that could lead to weak laws in other states and potentially a weak federal law. and that without baseline privacy protections, consumers won't have effective control over their information. Every fact about yourself would be observable by companies, especially since there are so many devices with microphones. Consumers would lose any zone of anonymity to exist unobserved, end quote. Do you think that's a fair assessment?
Well, I have no idea what we're going to look like in 10 years, but you can certainly extrapolate a world where our devices are watching us and we're not watching our devices. We saw last Christmas the FBI warn us about smart TVs. I think that that's certainly a possibility where our data travels without our knowledge around us in a way that hinders our opportunities, or maybe doesn't give us credit, or won't let us get a mortgage, maybe determines whether we get housing or not. And those are the concerns that we're really trying to address in this privacy bill is how do we make it work? How do we make it consumer focused? How do we have some kind of a nexus on consent in some way or another? And that's where these rights that came out of both Europe and California started. The right to delete, the right to know what they've got, the right to correct, the right to object. So I don't think you need to go through an opt-in on every single website you go to, but if we can craft a policy that has consumers understand when their data is being collected and being moved around, I think it'll help us avoid some kind of dark dystopic future where we don't have as much control over ourselves or the opportunities that are presented to us.
What do you think?
So three things that I want to point out. A, I think Maureen from Consumer Reports understands and expressed what's at stake. If we get this wrong in Washington State, it could have devastating impacts across the nation. We want transparency. We want accountability. We need to focus on three things. We need to build a bill that is about consumer empowerment. We need to make sure that we are clear on the corporate responsibilities, and we need to make sure we have strong enforcement. And that's so critical. Those are critical components to meaningful data privacy legislation. I want to say something about the opt-in or opt-out. Representative Hudgens is absolutely right in that we are really 20 years late because of the failure of federal government to act in setting appropriate sideboards around this. So we are having to play catch up, but we're demonstrating that in the European Union, it can work. Our international companies are operating under that right now. It's not as though it's not happening. So we need to be more thoughtful, I believe, about where are at least essential opt-ins. And certainly one of those would be, from my perspective, any of your unique biometric identifiers. There's a third thing that I want to say, because I think this is really important. We in the House, Representative Hudgens, other members, and myself, we've worked hard in a bipartisan way on these issues in the past. We've created, I think, almost all of the significant pieces of legislation that have been signed into law in Washington State to protect people's data privacy. We understand that this isn't a partisan issue. We are committed, and I am committed, and I know Representative Hudgens is committed to doing the right thing, but we have to. It is very difficult when you are responding to a corporate-centric bill. And that's why, to be honest, I put out an alternative which begins the conversation with the consumer, and that's the Charter of Personal Data Rights. Those are the discussions we need to have. And I think it's significant to note that the ACLU and the Attorney General of Washington State signed in for that charter in support of it, in part because it begins with the consumer. Not that it's perfect, but that's where we have to start with this legislation.
So when you look at the impact that some of the affected tech companies have on our economy, are there trade-offs to be weighed? I mean, could this put them at a disadvantage compared to other companies? Could it impact the state economy? And should that be part of this discussion?
I think that innovation is at their core. And we're seeing their ability to effectively respond to GDPR, which is the European model, which is considered the highest standard in the world. And they're operating within those economies. So, and granted, as Representative Hudgens mentioned, they have more robust enforcement, but that underscores the need that we see lacking, I think, in this current bill about how we're going to give people true access to justice if their rights are violated.
If I could just caveat on that, it has been reported, though, that the GDPR and California's privacy bill also have loopholes, and companies are working their way around them through the direction of the ad tech industry, which is really a central component of this that maybe doesn't get discussed as much. So is it possible to build a bulletproof bill?
Well, we talked about how you iterate on things. So you do the best you can, and you hope that you don't have loopholes, and then you try and close those. I think you shouldn't pass a bill knowing that there's problems with it. If you can fix things, you should do it right the first time. I also want to mention that we do balance the impact to our economy in everything we do.
Yes.
But we're talking about some fundamental rights, and we're talking about beyond just tech. We're talking about the banking industry, the credit unions, we're talking about insurance companies, housing. We're talking about healthcare data. Every time you park your car in a parking lot or use your credit card someplace, every time you walk down the street with some of these apps on, so there's geolocation data, we're talking about a lot more than just tech companies. The tech companies actually have been very involved in the process, have encouraged some kind of regulations so that they know what the rules of the road are. And we've been trying to learn from California and from Europe in order to put together the best piece of legislation we can that protects consumers, that's consumer focused, but really recognizes the unique economy we have out here in Washington State.
So we've got 2 minutes left. I want to switch gears and start, let's call this the lightning round, okay? Let's address facial recognition. There are 2 bills, one dealing with private, one dealing with the public sector, about whether and if or when this technology should be allowed. What are your thoughts about facial recognition in Washington and proposed legislation?
So both on facial recognition and the collection of, and the separate issue of our other unique biometric identifiers, I think needs a great more attention than we have given it, and if not moratorium, then sliding it, really constraining any deployment of that until we really sort out the ethical consequences, because we're seeing clearly the problems with those technologies as they're rolling out around the world. We don't have to look very far to see the consequences of using them in a way that is unjust.
And looking at the fact that there are already screening companies that use AI facial recognition to judge and rank candidates for jobs based on their speech patterns, their facial movements, et cetera, we know that this is already being used. What do you think about this technology and regulating it in Washington?
I think we need to be careful when, especially around constitutionally protected things,
Yes.
race, gender, class, economic opportunity. We need to make sure that people are making these decisions, not machines. And the machines and the algorithms should inform and assist in these decisions, whether it's getting a job, whether it's having a house, whether it's about getting a mortgage. That's our biggest concern, and that's our biggest concern around facial recognition as well, is that if we're not careful, it's going to amplify and accelerate our biases. We need to make sure that we're pausing enough to talk about this properly so we get the best use case scenario and we protect the public.
So we've
I
got
agree.
1 minute left, if we could. What's your worst case scenario if we don't get, or actually, how would you, for people that are just maybe completely befuddled by this whole conversation, what does this mean for me? What do you think this means for consumers down the road if this doesn't get reined in?
Well, I think the consequences are well documented. Consumers are feeling it today. It's not about reining it in down the road. It doesn't have to be an either or. We can live in a society where technology companies and innovation can provide the services that we appreciate, and we can have a meaningful voice in that exercise of free enterprise. Free enterprise requires a voluntary relationship. You give me something, I give you something, and we both understand. So it's about that transparency, clarity, clear understanding of what you're giving up to get that product. And I think we've done some great work in that space before. We can do it again.
And if you could quickly give me an example of a scenario where some of the data could be used in a way that might not be so great for somebody.
I think the whole discussion can be summed up in 2 quick questions, which is what data do they have and who's got control over it? So you can see an erosion of that process, how it's more difficult for a consumer to get that information, to control their data, and then it can be used against them in ways that they may not like or understand, and so that they may not be able to get a job or have housing because there's incorrect data being used, or they don't know the process. So we need more transparency, we need consumer focused, and that's, I think, the way we need to move in the future.
Well, we're out of time, but I'm sure we could talk about this. If we had more, we could spend an hour on this. But thank you very much, Representative Smith, Representative Hudgens. We appreciate your time.
Thank you.